Hussain-JCJ-2022 and the main examination, and today topic that I am going to deal is the Doctrine of Frustration under the Indian Contract Act. Could you see that what I posted on the screen? Please read. Could you see what I posted on the screen? Please read.
It's not displaying, sir.
Is it not displaying?
Yes, sir. Doctrine of Frustration under Indian Contract Act. This article is written by Roshan Rishwa.
Rishabh Soni, that Katasi third year, the law student, Amity Law School.
Sir.
Yes, it's the Doctrine of Frustration. Of course, we can tap from the various other people also, but I took it from him because he's compiled it. That's why a courtesy goes to him also, in addition to that, because already it is in the public domain. So when you see the introduction, frustration in general scenario means defeated, and this term has been widely used in agreements and contract between the parties. The term frustration is being used to deal with the unsuccessful transactions which could not be completed due to any reason. In law of contract, doctrine of frustration has emerged as one of the most common issues which have arrived to deal with the failed contracts. Can you tell me that which section deals under the Indian Contract Act regarding the frustration? Yes. If you know it, you tell me. If you don't know it, you say pass on.
Pass on, sir.
You already did it in the section 56. Now let us see that how it can be done, and it will be work. Doctrine of frustration. As a general rule, parties to the contract are having the intention towards the fulfillment of their part. In the case of the breach, party breaching is liable to compensate for the same. Now the question comes over there. If the breach is voluntary breach or the breach has occurred because of the act of God. Let us see that, but an exception to these rules laid down in section 56 of the Indian Contract Act. Could you read the Indian Contract Act in this style? Could you write the Indian Contract Act in this style?
Comma has to be kept after.
It should be the C should be the capital letter, and A should be the capital letter, and after the act, comma should have to come. Is it clear?
Sir.
Is it clear? Say
yes.
Sir. So that is the style of writing. So section 56 deals with the doctrine of frustration as being acts which cannot be performed. Why cannot be performed? Under this doctrine, a promisor is relieved of any liability under the contract in the event of a breach of a contract, and the contract will be deemed to be void. It becomes a void. Void becomes void. Suppose the subject matter itself is not in existence at the time because of the natural calamity or the act of God. At that times, we can say it is a doctrine of frustration. Am I right? Let us see that whether I am right or not. Like section 56 is based on the maxim, less non cogit ad impossibilia, which means that the law will not compel a man to do what he cannot possibly perform. He cannot possibly perform it. Like, can a man will walk in an hour 60 kilometers?
No, sir.
It is an impossible thing.
Yes, sir.
Suppose if you want to marry a particular man or a woman, a person, but the person is died because of the COVID. Impossibility. How could you marry when a person is died because of the COVID? Even though he or she made the promise to marry. So the basis of the doctrine of frustration was explained by the Supreme Court in the case of the Satyabrata Ghosh versus Mugni Ram. That is the case law. Satyabrata Ghosh versus Mugni
Ram.
Yes, in which Justice Mukherjee held that the basic idea upon which a doctrine of frustration is based is that of the impossibility of the performance of the contract, and the expression frustration and impossibility can also be used as synonym. Which are synonym?
Frustration and impossibility.
I appreciate. I appreciate. That means both are traveling in the same boat. Okay. The doctrine of frustration is, however, applicable only in two cases. If the object of the contract has become impossible to perform, number one, or an event has occurred making the performance of the contract to be impossible beyond the control of the promiser. These are the two conditions, then the impossibility will come. Like an illustration, it is given. Can you read the illustration?
Yes, sir.
Read.
A resident of India entered into a contract with B, a resident of China, for the export of rupees 550 heavy trucks. Initially, 100 trucks were delivered. Was Later war was announced between India and China, and the government of India suspended all the business transactions with China. Now, after this contract has become void,
Why?
because government of India has announced that business transactions should not take place, so it is impossible to perform the contract. It become it got frustrated, sir.
The reason is when a war is broken between the two countries, then we should not have a transaction with the enemy country. Then the doctrine of frustration will come out. Even though earlier there was a contract between the China and India, and some of the trucks are already exported or it's going to be export. So here a resident of India entered into a contract with the B, a resident of China, for the export of the 550 heavy trucks. What is meant by trucks?
10-wheeler, I think, sir.
It may be that sometimes the wheels are very big, wide, so those are heavy trucks, and they carry a lot of load also. Initially, 100 trucks were delivered because in the beginning, in the first installment, or initially the 100 trucks were already delivered. But later on there was a war which is broken between the India and China, and the government suspended all the contract business transactions because one should not have a business transaction with the enemy country. That's why everything is suspended. Then the contract of frustration will come into the picture. So after this contract has become a void automatically because of the war. Is it clear?
Yes, sir.
A and B contract to marry each other. Very good. And A is a man and a B is a woman. Let me presume. Are any one of them a different spouses? I mean different gender. Before the time fixed, the marriage A dies, and therefore the said contract become between the A and B will become a void, as one party to a contract has died. So when one of the parties died over there, then it will automatically the doctrine of frustration would come out because the subject matter itself is not present over there. Then there is no question of execution of a contract or an agreement. Is it clear?
Yes, sir.
Sir, if the elder daughter died, the second daughter the younger daughter is so beautiful, sir, why should not to marry her, sir? What is the contract?
Contract is between A and B only, so parties to the
At
contract.
the time, the contract is if the elder is a daughter, and when the elder daughter dies, the younger daughter is so smart more than the elder daughter, but we cannot insist him to give the younger daughter. Is it or not?
Sir.
Yes. Because
But
at
it
the
depends
time, she
upon
is not the party.
will and wishes,
Suppose,
sir.
suppose if the father agreed or the bridegroom also agreed, then
Then it depends on the whims and fancies of the
it
parties,
is
sir.
depends upon the contractual parties. If they are happy over there, doesn't matter. The contract will be fine. But when a party dies over there, at the time only the frustration will come out.
Yes, sir.
Is it clear?
Yes, sir.
The condition necessary for the application of the Section 56. There exists a valid and a subsisting contract between the parties. Existence of valid contract is the foremost condition for the application of the Section 56. The valid contract includes a contract entered in between the competent persons and which is followed by the same some consideration. If the party agrees together for the substitute or the alteration, then they can go for the contract. Then the contract is continued. Of course, the novation would be there. When the novation comes over there, naturally the original contract will be extinguished. Am I right?
Yes, sir.
Good. There must be some part of the contract which is to be performed. Let's see that. Like the earlier case law, 10 trucks were already supplied. So section 56 will have applicability only if there is some part of the contract which is yet to be performed. Without performing it to the ultimate purpose of the contract is not fulfilled. So now the question comes over there. When the frustration has come out, automatically the contract becomes a void. But if there is no such a frustration would be there, and if they still they want to perform it, let them perform if they agree together to the new terms and conditions. Is it clear?
Yes, sir.
So section 56 will have applicability only if there is some part of the contract which is yet to be performed, and without performing it, ultimate purpose of the contract is not fulfilled. Of course, let us suppose, let you take in this also. Suppose the contract is made between the two parties, that is the China and India. Before the supply of even the first installment, if the war breaks, automatically why? Am I right?
Yes, sir.
Good. Welcome, Venunath. Okay, now I am dealing the frustration of the contract. Do you have any idea regarding the frustration of the contract?
Good evening, sir. Good evening. Sorry.
Sound is very low. Okay, let
Good
me
evening.
continue.
Good
The
evening. Good evening.
contract, after it is entered into, becomes impossible of performance. Another important condition for the application of the section 56 is that contract, after it has been entered into, has become impossible to perform and cannot be performed. Therefore, contract stands void. Like I told you that if A and B agreed to marry each other and both are having opposite sex, any one of them died, then automatically
Contract become frustrated.
then it becomes void because of the doctrine of frustration, because one of the parties is not in existence, so impossibility would be there.
But in France, if a person, let's say, दोनों के एंगेजमेंट हो गया है
Okay.
और उसमें से एक आदमी का, लेट्स से लड़का लड़की के एंगेजमेंट हो गया,
Okay.
उसमें से एक आदमी, वन पर्सन डाइज,
Okay.
the girl or the boy can make an application to the government stating that I want to get married to this person, means वो मरो आदमी के साथ उनका शादी करता है उसमें. It is there in
Okay.
France law. That is exempted in France.
Yeah, if the party, suppose you want to marry a elder daughter of a particular person, and the elder daughter died, but younger is more beautiful than the elder, and if they agree together,
No. That is different. I'm not saying that is different.
no,
But
no,
they are
no,
marrying
no.
a dead
In this
person.
situation, you tell me. In this situation, you tell me.
That depends on
That depends upon the mutual agreement between the parties are concerned.
Yes, but in France, you can marry a dead person also.
Yeah. I think that
What
is
is
that.
the purpose of marriage, sir? If
Yeah.
any person is married to dead person, what is the purpose of marriage and how marital life will
Wallet, money, finance.
No, not valid money finance. If I'm in love with someone and if that person dies premature, so I want to marry earlier I wanted to get married to him. Now he's died, but I want to be his wife even after dead. So उनके साथ शादी कर जाए. The only marriage will happen. But
because of
property will
sentiment,
because of emotionally, psychologically, it is allowed in France.
So thank God, still we are the same persons, especially myself. Okay, let us come to another point. Because the society is a mixture of many things, so we cannot say anything to anybody. So generally, a frustration of contract can be in the following cases: death or incapacity of a party. Where a party to the contract has died, after entering into a contract, are the parties incapable of performing the contract? In such a situation, the contract will be void. Suppose if a person became a bankrupt or insolvent, and at the time that he could not do so, then what is the situation? The contracts become void or not because of the frustration.
Sir.
So Robinson versus Davison, that the case law shows over there. If a person becomes incapable of performing such a contract which is already agreed, at the time it will be a void. Is it clear?
Yes, sir.
Frustration by virtue of legislation. Now let us see how the legislation will make the thing a contract will be frustrated. Where a law promulgated after the contract is made makes the performance of the agreement impossible. Thereby the agreement becomes a void. Suppose they made a contract between the two parties of supply of certain provisions, but later on the government say the provision is banned to sell in the market. Is it kerosene is banned to sell in the market?
Yes, kerosene is banned.
But still I could see that kerosene tablets are sold.
No, but they are sold by some other name. Kerosene you don't
Sold
get
by
nowadays.
other name. Okay. But the composition is the same.
Yes. The formula will be remains. Now you'll get it by paracetamol, by name paracetamol.
Okay.
Not by kerosene name.
Okay, right. See what the kerosene composition does. The same thing Dolo will does. But why the Dolo is so much famous? Is it a market trend? Are the multinational companies?
You won't believe. I'll tell you about Dolo case history, which has come in Supreme Court.
Yeah. Because it also appeared in the newspaper also, no?
Yes. The Dolo company has paid more than 1,000 crores to the doctors to prescribe their drugs.
Yeah.
Only Dolo.
Yeah.
Only Dolo 650. Because as per the pharmacy law,
Yeah.
any tablet which has less than 500 mg,
Okay.
the government has control on pricing.
Yeah.
But if the mg increases beyond 500,
Yeah.
the government doesn't have control on that. It will be the company's control on what should be the price on it.
Okay.
So that is why Dolo 650, they spend huge amount. They spend more than 1,000 crores.
Okay.
So that in places like this COVID and other severe fevers,
Yeah.
doctors only prescribe Dolo 650, no other medicine. That is the reason.
Okay. So now even the same another paracetamol also could do the same thing.
But
Okay,
doctors.
now let us see frustration due to the change of circumstances. This particular situation deals with those cases where there was no physical impossibility of the performance of the contract, but because of the change in the circumstances, the main purpose for which the contract was entered has been defeated. So the purpose is the rainy season is there. In the rainy season, what will be needed?
Umbrella,
raincoat, and so on and so forth. If the rainy season already gone over there, and there is no again demand, then there is no necessity of it because the already season changed.
It's a demand and supply issue then.
Yeah, at the time there is no necessity of the thing. Automatically it will be frustrated because the purpose, the order in that within time, if it doesn't reach over there, then it the purpose is defeated. So naturally, when such a thing, all the circumstances changes, then automatically it becomes a frustration and it becomes a void. So initial versus subsequent impossibility. What is, let us see. Initial impossibility. That means the object of making any contract is that parties to a contract would perform their respective promises. Yes. Promises are there to keep or promises are there to break?
To keep.
That depends on situation to situation.
A gentleman agreement is promises are to be kept. So, respective promises and where the contract is impossible to perform, the parties would never enter into it. When it becomes impossible, Suppose the subject matter itself is disappeared, no more in existence, then automatically the contract will be frustrated. Initial
Okay.
impossibility deals with those cases where the contract was impossible to perform from the very beginning. For example, if a married man, knowing that he can't marry again, promised to do so, then he is bound to compensate the other party. Because initially he could not do so. Why? Why?
Participant.
Already that
Yes.
spouse is living. Is it clear?
Yeah.
Yes, sir.
So a married man having a spouse living at the time, he cannot promise to the another woman to get married. Then he is bound to compensate to the other party when he does so. Subsequent impossibility. It deals that with the case where the contract was possible to perform when it was entered into, but because of some event, the performance has become impossible or unlawful, and therefore it discharged the party from the performing it. For example, if A purchased a ticket from B for watching a cricket match and he pays 50% as an advance also, if the match is cancelled,
No money.
then A cannot recover from B as the
Yes.
cancellation of match was beyond the control of A.
Mm.
Can he demand the 50% which is paid over there?
No, 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 no. How can he demand?
See,
He
it is
cannot demand.
his luck. It is his favor. Is it or not?
Yes.
Suppose if it is not cancelled, he would have to enjoy it. Is it not?
Yeah, yeah.
But the cancellation come only later part of it. And both of the party doesn't have the knowledge.
Mm.
Suppose if he knows that the match will be cancelled. Suppose if he sell with intentionally to the 50% without informing him that
That is
that time
fraud.
now you tell me.
That is fraud.
Even even if he knows that he knows the match will be cancelled, but he never revealed to the person that when he was going to sell the ticket.
There is something called, there is a difference between fraud and misrepresentation.
Okay. So of course, the bona fidely he also doesn't know it at the time, he cannot get it back. So doctrine of frustration is applicable only in the case of the subsequent impossibility, not the primary impossibility. Is it clear?
Yeah.
In the initial impossibility means a married man cannot promise to somebody else when the wife is alive to get married to another woman. It is the
Mm.
initial. But the subsequent, it becomes impossible. Yes, it is a frustration. Doctrine of frustration is applicable only in the case of the subsequent impossibility, where the contract was impossible to perform from the beginning, where the doctrine has no application. Moreover, the doctrine will also not applicable in cases where there was a mere delay in performance and contract still be performed. Merely delay will not be a frustration. So, the doctrine of frustration, as enshrined in the Section 56 of the Indian Contract Act 1872, deals with those cases where the performance of the contract has been frustrated and the performance of it has become impossible to perform due to any unavoidable reasons or conditions. This doctrine is treated as an exception to the general rule which provides the compensation in case of a breach of a contract, but Section 56 only deals with the cases of subsequent impossibility as about to opposed to the cases of the initial impossibility. So that was the thing. And some of the case law also that he has given in the doctrine of frustration here, where the doctrine of frustration is covered under the Section 56 of the Indian Contract Act 1872. Now let us see one of the case law. Initial impossibility. No, we will say one of the case law. Supreme Court decision judgment was Satyabra Ghosh versus that we already Mugli Ram that we already discussed this case law. But let us see the another case law, the Taylor versus Cadwell, AR 1863 case law. It was held in this case that the contract never positive and absolute contract, subject to an express or implied condition, particularly things shall continue to exist, contract of performance deemed to the impossible, and both the parties to perform the contract was are excused. Example, A, let analyze with the help of X and Y. Let me see. A, let analyze with the help of X and Y. And X agreed with Y to give him a music hall to use and a garden for 4 different dates for holding the concerts. Y sued X for the breach of the contract. Okay. Held that without any fault of X, hall becomes perishing. If the hall becomes perishing, of course it deteriorated or burnt. Hence, the contract becomes a void. Suppose the hall is burnt because of the short circuit. At the time, the contract becomes frustrated. And contract performance done by X becomes impossible. And hence, X was not liable for the non performance of the contract. Is it clear?
Yes, sir.
So, Alluri Narayana Murthy, Raja versus District Collector Vishakhapatnam. Can anyone unmute and read?
It was held in this case that the Maddi Gram Panchayat of Vishakhapatnam district, there under a contract, petitioner granted leasehold rights for lifting the sand in a river. The residents of the village prevented him from carrying on quarry operations on the ground that it would lead to depletion of the groundwater affecting the irrigation channels. The villagers were um, undeterred even by registration of criminal case against them and also by grant of injunction by civil court. Uncontroverted facts was that on account of the event subsequent to entering into the contract, control the parties of contract becomes impossible. Section 56 of the Contract Act 1872. Therefore, doctrine of frustration was applied to all force of contract.
Yes. Here, lifting the sand from the river is the depletion of the water and the irrigation will be affected over there. That's why the villagers struck down, stopped them not to lift the sand from there. So when they made very much clear, of course, they say the decree also will be passed over there, even though the decree will not be passed by the government because there is a depletion of the water level would be there. So the villagers were undeterred even by the registration of a criminal case against them and also by grant of injunction by the civil court. Even the civil court also made such a thing would be there, but they completely the total village is against to it. Then automatically it will be frustrated. Now nobody could do it. Nobody could even do it because everybody is against such a lifting of the sand. Is it, Venunath, are you hearing
Yes,
me?
sir. Yeah,
Is it
yeah, yeah.
not amount to the contempt of the court when the civil decree is given by the court?
No, in one way, it may amount to contempt of court, but looking into larger interest of people,
Yes.
the court will not take into contempt of court because these people are fighting for the welfare of
Public at
the village,
large.
public at large, not for one individual person.
Yeah, not for the individual.
Yes, yes. In that cases, in such cases, the court will not take it as contempt of.
Okay, okay. So
Against the
now,
law, what these people are.
okay. Self-induced frustration, doctrine of frustration of contract cannot allege an event to have a frustrated the contract arise from the act on election of party. If the self-induced such a impossibility would be there, means intentionally,
Yeah, yeah.
then the doctrine of frustration could not be applied over there. Now,
Hmm.
the Bhuta Linga agency versus TC Puriswamy Nedar.
Nadar, Nadar,
Nadar.
Nadar.
AR 1969 Supreme Court SCR. What is the full form of SCR?
Supreme Court reporter.
Okay.
Reporter, Supreme Court report.
Okay. What is SCC?
Supreme Court cases.
Good. Supreme Court, comprising English law and Indian law, contained in the section 56 of the Indian Contract Act, legal position with regard to the frustration. Case law in India, contract of doctrine of frustration is really an aspect or a discharge of contract of the law or supervening illegality or impossibility of the act agreed to be done purview of the section 56 of the Indian Contract Act. So the rule of positive law that does not leave the matter to be done determined by the intention of the parties. Case law of English law of construction has been determined by the court upon the true intention of the parties. Section 56 of the Indian Contract Act lays down a positive rule, and English authority cannot assist the direct persuasive value how English courts decided the cases. Of course, specific grounds for the frustration are the destruction of the subject matter, or the change of the circumstances, non occurrence of the contemplated event, or death or incapacity of the party, or government administration or a legislative intervention would be there, or the intervention of war or application of the leases. So these are all the factors which will make it the contract to be frustrated. So one of the case law here, Howell versus Copeland, this case law which I am reading now, is it visible? Say yes. Held in this case, it was held at the potatoes. At the time of the contract, potatoes had been grown but destroyed by the disease. It is clear by authorities would have excused. Here it was an agreement to sell specific things. Neither the party is liable if the performance become impossible. Why the performance become impossible? Because potatoes are potatoes are
Destroyed.
Perishable item.
no, it is infected with a disease, mut, some potato rut or potato mut or any other disease would be there, and hence it cannot be consumable in nature at the time. It becomes impossible. It is infected. So, non-occurrence of a contemplated event, the performance of the contract entirely remain impossible, but owing to the event, but both the parties contemplated and non-occurrences, performance of the value is destroyed. That the case, when the subject matter would be destroyed, subsequently, then automatically Section 56 could be applied. Even
Okay.
the death also, or incapacity also. Is it or not? So can you read the Arti Sukhdev Kashyap ORS versus Daya Kishore Arora? Yes.
It
Read.
was held in this case was that the performance has been delayed. Contract of frustration does not mean before the expiry of 10 years, permission for sale could not be granted. In this case, there was allotment of plat by development authority, no exceptional circumstances, and permission for sale was requested, was refused. Then afterwards, there was a possibility of sale after 10 years, contract not frustrated.
For merely delay doesn't make the contract would be frustrated. That is the gist of it. But later on it can be continued. When it will be continued, then frustration cannot be, Section 56 cannot be applied over there. Is it clear?
Yes, sir.
Then Haraprasad Chaubey versus Union of India, it was held in this that here the appellant was the highest bidder for slack coal belonging to the respondent railway. Full payment by the appellant for the same. When he applied for the wagon for transporting coal to the Firozabad, coal commissioner was refused to the same on the ground that the coal was meant to be consumed locally only. When the auction, the coal was made no such condition. For the refund of the amount paid by him, appellant then filed a suit, also filed a suit against the permission, and also contract becomes frustrated on the ground of amount of the interest, and transport coal was also refused. When really it is used for the local consumption would be there, then at the time the bidding amount will be returned back to the bidder. The claim of the appellant was accepted and also accepted to refund the money. Decision was that the coal commissioner refusal to allow the movement of the coal to the Firozabad, in spite of fact that the time of action that no such condition was there, had frustrated the contract. When the bidding was there, there is no such a condition that it will be used only for the local people. But later on, it is made. But at the time, it is not amount to. It is then at the time it becomes a frustrated because the entire coal stock would be consumed by the local authorities only. So this way, there are number of cases are there, but still we do have some time in your hand. Yeah, will still do have some time in your hand so that we can deal with some other cases also. So no frustration of executed contracts. Section 56 does not cover or apply to the executed contracts only and does not apply to executed contract. I repeat, Section 56 does not cover or apply to executed contract. What is meant by executed contracts? Yes,
An agreement or
already
a contract
passed
which is
one.
signed. It's a past tense.
Executory contract or executed contract. Let us see that Amir Chand versus Chuni Lal, that the AR 1919, Punjab and Haryana, 345 page, it was held in this case that the doctrine of frustration does not apply in the estate or interest of creating the contract in land in terms of the decree the tenant of the house was evicted. For the restoration of the possession, the tenant filled an application before the executing a court landlord, then the pleaded that the building standing on the land has been demolished by the municipal committee. There was no building, only vacant land. Also, tenant was also not entitled to the land. So it was held that the contract of lease had not become impossible of performance because the landlord could reconstruct the premises in the same form they existed before the demolition, and the right of the lessor and the lessee in respect of the new premises would be then available. Suppose if it is demolished over there in the beginning, but later on the landlord would try to make the new construction would be there at the time. At the time, landlord will provide such a facility to the leaseholders. Is it?
Yes,
Yes.
yes.
Suppose if it is not there, okay, later on that he made the old construction was there, he raised to the ground and he removed it, but the new construction made over there, but he promised that he will make it to them when the new construction is over. Again, they will give it. Okay, now the new construction cost is more, then he may increase the rent or may not increase the rent.
He will increase, sir.
If the amount which was given over there, the amount which now he is fixing over there, if there is a difference would be there, that will be paid by the lease, the tenants, and they have to enter into it. Because facilities are given more. When the facilities are given more, rent would be the
More.
say more. Okay. So now let us see that mere likely delay in the performance. No frustration. Merely likely delay is not a frustration because it can be done later part also. As we know that the performance should become unlawful or impossible, then only the frustration will work over there. And in such a case, object of the party merely delay in the performance, not amount of impossibility. Merely delay is not an impossibility and they're totally upset. Delay in the performance of the contract does not apply like the case of the Satyabrata Ghosh versus Mugni Ram. In certain cases, even delay also frustrate it when the time factor is the essence of the contract. Am I right?
Yes. Yes, yes.
See, the tomato season is there. The tomato season, tomato is cheap. And suppose If the tomatoes came out of the season would be there, then of course by that time the tomatoes will be no more in a good condition. It will be putrid or it will be decayed. If it takes a 10 to 20 days in transaction itself, how many days the tomato will sustain fresh?
Fresh maximum for 3 days.
If it is a green tomatoes,
Green or red,
eh?
any tomato.
Any
Green or
tomato
red.
it will be rotten after 3 days.
Yeah, 2 to 3 days. Because
Yeah.
that depend on which climate you keep the tomatoes.
Climate is more important factors.
Yes.
So merely delay doesn't make it is a frustration. The commercial difficult does not mean mere impossibility. See, commercial difficulty is a different thing, and impossibility is a different thing. And control of the promisor event makes the performance more expensive and difficult. There, the nature and terms of the contract may decide whether the performance has become impossible or merely commercially difficult. So the supply will reach it in time is well and good. But the supply reach when their purpose is served over there is no use at all, then it will become a frustrated. Or if merely a delay doesn't make anything, then it will be continued. Then the section 56 cannot be applied over there. Then Panj Sons Private Limited versus Union of India, it was held that the case there was a contract between the Mrs. Panj Sons Private Limited and the Union of India, under which the farmer agreed to supply the later milk containers of 20 liters each with the hot dip coating container were coated. Means they are the Panj Sons are the supplier of the container to the Union of India. What container? Milk containers. And what happened? Coating was done by tin ignots, also not available in the market. At the time, the coating which will be done to the container should be that the tin ignot which are not available in the market on the
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे अहरह तव आह्वान प्रचारित सुनि तव उदार